Hello, my name is Sarah Madden and I am Legal Counsel and Privacy Officer for the Department of Elementary and Secondary Education. I'd like to welcome you to training on the Family Educational Rights and Privacy Act, otherwise known as FERPA. This is the second in a series of trainings prepared for DESE staff that are available on Mo LinkedIn Learning. The other training is on Missouri's Open Records and Meetings Law, otherwise known as the Sunshine Law, and it focuses on transparency. This training focuses on confidentiality. It's important to take both trainings and see how the two obligations, confidentiality and transparency, fit together and how they don't. The transparency obligation comes from Missouri statute and ethical requirements. As we talk about in the Sunshine Law training, there is an obligation to be transparent that comes from the fact that our work is paid for by taxpayer dollars. As a result, we need to be open and transparent about the work we do. The confidentiality obligation comes from a variety of laws. FERPA is one of them, and also a right to privacy. As a result, we have two competing obligations that we're going to talk about a little bit more in this presentation, and how to navigate those two competing interests. The first question is, what is FERPA? And very briefly, it's the federal law that protects confidentiality of student records and protects the privacy and of parents and students. So FERPA is a 1970s era law. It came out of the same time period as the Freedom of Information Act, which gave rise to Missouri's Sunshine Law. They're similar in that at that time in the 70s, government was starting to accumulate quite a bit of data concerning people and families, and that came out of a widespread use of computers. So computers for the first time were collecting massive amounts of data. At that point, the public, legislators started to think maybe we need to put the brakes on this use of data and how it's collected, how it's maintained, and how it's accessed. So who does FERPA apply to? The law applies to any public or private elementary, secondary, or post-secondary school and any state or local education agency, meaning SEA or LEA, that receives federal funds. So in sum, any SEA or LEA that receives federal money or institutions of higher learning is subject to FERPA. What are the main objectives of FERPA? Okay, so we'll come back to this slide several times in the presentation. So keep these points in mind. The law gives students and families the right to access and amend their own education records. And FERPA also prohibits the release of a student's identifiable education record to third parties without the consent of the student or the family, unless an exception to the FERPA law is met. Now, FERPA has lots of exceptions. We'll talk about some of them. Each one is different, and we have to analyze it carefully before we release records. I also want to note the use of the term education records. We'll explore that term a little bit later in this presentation. So high-level takeaways. The first and most important is protecting the privacy of students is a legal and an ethical responsibility, and it's part of our culture here at DESE. No matter who you are or what office you work in, FERPA affects the work you do on a daily basis as a DESE employee. And we'll talk about how that is a little bit more. FERPA, and I'm not going to minimize this, it's a complex law, and it has components that have to be studied very carefully each time we release student records. And finally, FERPA contains mechanisms for withholding federal funds if the law is violated. So that being the case, if you have any doubts about how FERPA operates or how you should handle student records, contact legal counsel with questions. Okay, so you might have already guessed how or why FERPA matters to DESE employees, just from what I was saying. But why does FERPA matter to DESE employees? Well, let's connect the dots here. Remember, FERPA applies to SEAs, state educational agencies like DESE, and LEAs that receive federal funding. DESE, of course, receives federal funding and is an SEA. Also, FERPA applies to DESE because it operates state schools or LEAs. So, in that way, FERPA applies to DESE doubly. It applies to it as an SEA and as an operator of LEAs. DESE employees have to have a basic knowledge of how FERPA operates. And they also need to know where they can go when they have questions. Let's talk a little bit about the kinds of requests or questions that DESE employees get about student information. And again, I cannot emphasize enough that it doesn't matter what office you work in, you will cross paths with student records or education records. This could be anything from a data request for student information from our core data or Missouri Student Information System, or MOSIS. It could be a request for adult education records. It could be a request from a state school, or it could be a request for IEP information to confirm that a student is eligible to be placed in a summer work program for our vocational rehab program. It could be a subpoena for student records, or it could be publication of a name or a photo of a student in DESE social media. Again, it doesn't matter what office you work in, FERPA impacts all of us. So let's talk about some key concepts here. And as I mentioned before, we would come back to this term, education records. Education records are records that are directly related to a student and those that are maintained by the educational agency or institution or a party acting for the agency or institution. So it's a very broad definition. Remember, as we said kind of at the top, FERPA gives students and parents the right to amend or access their education records, and it prohibits the disclosure of education records to a third party without a release unless it meets one of the FERPA exceptions. So for DESE's purposes, what are education records? Education records at DESE are all records relating to a student that are maintained by DESE or by a party on DESE's behalf, such as a contractor. So again, it's that very broad definition of records that are relating to a student that are maintained by DESE. Let's talk about PII. And I think most of us have just a sort of a general definition of what PII is, but what is PII in the FERPA context? PII is a student's name, the name of the student's parents or family members, personal identifiers like social security numbers or the student number, Missouri student number, also known as MOSIS ID number. It also includes indirect identifiers, dates of birth, place of birth, mother's maiden name. And when we talk about indirect identifiers, that we call them indirect identifiers because it could apply to more than one person. It could apply to siblings. Siblings could have the same maiden name, or it could apply to different people. Different people could have the same place of birth or date of birth. So that's why it's indirect. And then there's this third category of personal identifiable information, other information, and I'll read you this definition of other information. It's alone or in combination that's linkable to a specific student that would allow a reasonable person in the school community who does not have personal knowledge of the relevant circumstances to identify the student with reasonable certainty. What are we talking about in this last category? So we're talking about any descriptors that would lead to the identification of a student. So what if I provided these descriptors to you? Young, green, male, Jedi, loves frog eggs. Would you know who I was talking about? So if you guessed Baby Yoda, you guessed correctly. And even though that I didn't provide you the name of the individual I was talking about. So that's how other information it can be used to identify someone or something. It can be considered personal identifiable information. Similarly, providing the race, free and reduced lunch status, IEP status, activities, suspension, expulsions, graduation status, alone or in combination with other categories of information could lead to the identification of a student. What are some examples within DESE of records containing PI? So many. It could be correspondence that's between parents and school districts that's been sent to DESE. Could be child complaint decisions that are maintained by the Office of Special Education. It could be applications for disability determination services that have IEP records that are sent with them, that are maintained by vocational rehabilitation or disability determinations. It could be just MOSIS data. It could be MOCAP appeals. It could be student records that are maintained by one of our state schools for the disabled, by the Missouri State School for the Severely Disabled, the Missouri School for the Blind, or Missouri School for the Deaf. Or it could even be a photo of a student that was taken at a district with the commissioner. All of these are examples of PII that DESE would maintain. So let's do a pop quiz. We have a 16-year-old who is working from his basement, and he calls himself a Twitter journalist, #DisruptDESE. He's requested from DESE a breakdown of the number of students from his building for the 2018-19 school year who were suspended or expelled by race or ethnicity, by free and reduced lunch status, by IEP status, and by homeroom. Can DESE provide this information? So the answer is no, probably not as the request is written, because of the risk that students might be identifiable in the combination of data elements that's been requested. So again, the key here is if the information alone or in combination is linkable to a specific student. We go back to that definition of PII that's found within FERPA. So to reiterate, FERPA prohibits DESE from releasing a student's education records, or PII, unless a FERPA exception is met. It's important to know that parents can always release the records of their children. The parents are always in the driver's seat. So, when we talk about parents, what do we mean by that? We mean that that could be both or either parent. We mean, we could be including a court-appointed guardian. It could be somebody who's acting in the absence of a parent. That could be a foster parent or children's division. Or we mean the student themselves if the student is older than 18 or older, I'm sorry. And when we're talking about a student who's 18 or older, we're talking about an eligible student. That's the term for those students. So again, the parent can always consent to the release of records. So other than a parent, who can release education records? This is where we get into the exceptions that we've sort of referred to when we talk about FERPA. In some cases, a decision maker can also be an LEA if the disclosure meets certain conditions, or it could be an SEA, again, if the disclosure meets certain conditions. So let's go back to a parent being the educational decision maker as far as the release of records. What will a parent or eligible student request look like? This can go down two tracks. It could be a request from a parent, and when I say parent, I'm also including eligible student, the 18 or older student here. If it's a request from a parent to DESE for the records, that's one track. It could also be a request from a parent to DESE to release the records to a third party. That's the second track, and we'll talk about that in a second. So let's talk about track one here. And again, that track is a request to DESE for records to the parent. And what FERPA says is, that request can be pretty simple. all that request needs to have is, the request has to be in writing. It has to specify the records being requested, and DESE has to know that the parent is in fact a parent, or again, if it's the eligible student, that the eligible student is who the student says he or she is. Now, the parent question can be a little bit tricky, especially when we have two parents who are perhaps acting independently of each other. If you have any questions about how to make that determination or how to work a response to that kind of release, please talk to legal counsel. Now for that second track, again, this is if a parent asks DESE to release records to a third party. FERPA asks for a little bit more. FERPA says that that kind of request has to be in writing, it has to be dated, it has to be signed, it has to specify the records requested, it has to state the purpose for the disclosure, and finally it has to identify the party to whom the disclosure is made. So again, a little bit more, more requirements to make sure that the records are going to, the intended party, and that the release meets all of these requirements. So let's do another pop quiz. DESE receives a request from a very secretive branch of the federal government to confirm that John Doe graduated from high school in Missouri. The request contains Mr. Doe's signature, the dates of his high school attendance, and a short note from Mr. Doe that details his love for Kansas City barbecue, which he says is 1,000,000 times better than that in his new, very secret location. Can DESE confirm Mr. Doe's attendance? The answer here is no, because if we think back to the requirements for a third-party release, it doesn't meet all of them. It's not dated, it doesn't provide the purpose, and it doesn't identify to whom the records will be disclosed. Now, in this case, we would send a response that identifies what the deficiencies for the request are, and we would typically send a FERPA release form that DESE has created to help the requester, better articulate the requests that they're wanting to send and meet all of those requirements that are laid out in FERPA. Okay, we've talked about the release of records if a parent authorizes it or an eligible student. Let's talk about releases authorized under FERPA exceptions. So these exceptions apply to state schools, and I hope everybody just bears with me as we talk through these because I think they're important for everybody to hear. The first couple, may be familiar to those of you who have kids in schools. The first is, an internal release from one school official, from the school to a designated school official who has a legitimate educational interest. The second is when a student transfers from one school to another. And then another exception is to respond to a judicial order or a lawfully issued subpoena, and we do get those from time to time. Now, note that if we're responding to a subpoena, we have to give the parents notice in advance unless the subpoena specifically prohibits that. And then another is, in a health or safety or, pandemic emergency, and that's something that school districts certainly became familiar with during the COVID-19 pandemic. And I just want to emphasize that this is an abbreviated list. This certainly doesn't cover all of them, but it covers some of the most common. Okay, so let's talk about when consent isn't needed for DESE. And, again, this is just going to be an abbreviated list, but we'll talk about some of the most common ones. And the first two categories that I'm going to talk about relate to MOAs, or memorandums of agreement or understanding between DESE and researchers. And the first is for a study on behalf of DESE or an educational agency. The second is for a program audit or evaluation. these can be done, these audits and evaluations or studies can be done at the request of DESE or a researcher, and we have to meet all the requirements that are laid out in FERPA for audit and evaluations or studies, and there are quite a few. And those ensure that when we're giving data to a third party, that data is protected securely and isn't passed on to another party after that, without our knowledge. And then the last one I have here is to comply with a judicial order or lawfully issued subpoena. And the same rules apply there as we talked about before. Let's talk about what's not covered by FERPA. And parents, this is another one that you might be familiar with. For state schools, what's known as directory information is exempt from FERPA. And directory information is information that, if disclosed, would not generally be considered harmful or an invasion of privacy. And that would include student name, address, phone number, email address, things like that. Now, it's important to know that students and families have a right to opt out of inclusion in disclosures of directory information. Now, this sounds a lot like PII, doesn't it? The distinction is that in each LEA, the LEA determines what would be included in directory information. And more importantly, students and families can opt out of directory information and what would be disclosed. So, we want to make that distinction that PII is not the same as directory information. There's always a right to opt out of providing directory information. And then there's another important thing to think through here is, the directory information definition and exception, it really only applies to state schools. For the rest of DESE, we do not know what information LEAs have designated as directory information. And we wouldn't know what students would have opted out. So don't ever assume that if you get a request for something that looks like directory information, we can provide it, because we don't have that knowledge of how LEAs have handled the definitions of directory information and what students and families have opted out. Okay, so along those same lines, let's do another pop quiz. The Ozark River Free Press has asked for a list of students with the names of their districts so they can provide a special back-to-school edition for the whole state of Missouri. Can DESE provide this list? So think back to what we know about directory information and DESE's ability to provide it. The answer is no. DESE could not do so without a release from each parent or eligible student. DESE doesn't know how each school designates directory information and doesn't know what students would have opted out. Even if the information looks like directory information, without contacting each family, DESE couldn't provide this list. So let's talk about special issues affecting data management staff. I first want to refresh on how the Sunshine Law intersects with data requests. As we remember, Chapter 610, or Missouri Sunshine Law, requires, among other things, that the public, have the ability to request documents from public governmental bodies. And public governmental bodies, like DESE, have to provide documents that are, 1, maintained by the public governmental body, and 2, in existence at the time of the request, unless there's an exception in state or federal law that keeps them closed. And if you've already taken advantage of the Sunshine Law presentation, these are concepts that we talked about quite a bit. And we know that FERPA is one of those exceptions that keeps records closed. It is an exception to the Sunshine Law. So if DESE receives a request for student records or a record that contains student PII, remember that we have 3 business days to provide some type of response to comply with the Sunshine Law. Again, the response doesn't have to include the records. It does have to be some type of response, though, acknowledging receipt of the request. ultimately, the response is based on whether we have the record and whether the requester is entitled to, the student records or PII, based on who they are and what's in the records themselves. So, you'll want to work with legal counsel, my office, or your legal counsel to ensure that we're protecting student confidentiality and complying with the Sunshine Law. Those are two, we've talked about these competing interests. Those are two competing interests that you'll have to work through with that type of request. So just to review the data request process, and I know all of you are familiar with this, but just want to talk through it. ODSOM's data request process allows individuals to submit unit level data requests for reports that are specific to the individual request. Now, just to clarify, these requests fall out of the Sunshine Law because they're asking for records that are not in existence at the time of the request or maintained by the public governmental body. So again, to reiterate, we've got Sunshine Law requests that are asking for a record that is in existence at the time of the request and maintained by the public governmental body. So that's bucket, the Sunshine Law bucket. And then we've got the information or data request bucket. And those are asking for new records or new reports that are not in existence at the time of the request or maintained by the public governmental body. And that's the data request process. Remember that all requests, regardless of what kind of requests they are, we provide a response within 3 business days because, we just want to make sure that if there's a Sunshine Law element to a request that, we don't want to miss it. So we're always going to provide some kind of response within 3 days. So, when we think about what a Sunshine Law request looks like, it's asking for anything that is already in existence and maintained by the public governmental body, by DESE. So that could be a data set that already exists. A request may use the words Sunshine Law or Chapter 610 or records request, but it doesn't have to. All it has to do is ask for something that we already have. If it does, we treat it like a Sunshine Law request. So what do you do if you get a Sunshine Law request? You send it to the records custodian email address immediately because we have that 3-day time frame for a response. And then, one question that comes up frequently is about charging. Can we charge for a data request? Can we charge for a Sunshine Law request? The answer is yes. We can charge under the Sunshine Law for the creation of new records. And we can also charge for the retrieval of existing records if there's a cost. But keep in mind, typically you're not going to have a cost associated with finding, an existing data set. But if there is, we can certainly charge for it. So what do you do if you have a request that is a request for a new record? So the information data request bucket, but it also has a Sunshine Law request. So the Sunshine Law request bucket, it's got both. Forward that request to the records custodian email address as well, and we'll coordinate on how we're going to respond. Okay, so let's touch on how we can craft FERPA-compliant MOUs and MOAs. This gets into what we've already touched on a little bit about the exceptions to FERPA dealing with the studies and audit and evaluation exceptions, but we're going to dive into them a little bit more deeply. So the studies exception is for when we're disclosing to an organization that's conducting a study on our behalf, DESE or another educational agency, for the following purposes: to develop, validate, or administer predictive tests, administer a student aid program, or improve instruction. And honestly, the improving instruction bullet is really the most common one that we use. And then the audit and evaluation exception is the second FERPA exception that is used for these data studies or agreements. And this is to an authorized representative, in connection with an audit or evaluation of a education program, a federal or state-supported education program, for the enforcement or compliance of a federal legal requirement that relates to one of the programs. Now, I will note that even though we talked about this being a disclosure to an authorized representative for the audit and evaluation exception, for both the studies exception and the audit and evaluation exception, we require a disclosure to an authorized representative. And this is a small legal distinction, but it means that the party that receives the education record data in both instances will be safeguarding it to the highest FERPA standards. So, both data sharing agreements, the studies agreement and the audit and evaluation agreement, have quite a few common requirements. They require that there be a written agreement, that there's a clear statement of scope and purpose. The PII has to be destroyed when it's no longer needed. That data that's published protects the privacy of students and families. Only individuals with a legitimate interest, educational interest, has access to the data. The data has to be, kept securely, and DESE has the right to audit third-party practices. What about requests from LEAs? And this is a question that comes up not infrequently. DESE has access to LEA data because DESE is considered a school official, and we talked about what that means, a little earlier in the presentation. Also, DESE has access to LEA data in some cases because of the audit and evaluation data sharing agreements. In all cases, if an LEA makes a request of data, we have to ask ourselves first if the LEA would be entitled to that information because they initially had access to it. If the answer is yes, then we need to provide it. Okay, let's talk about parent requests. Now, we talked at the beginning of the presentation as one of the two objectives of FERPA is that FERPA provides parents the right to inspect and review student education records. This includes records maintained by the SEA. So, keep in mind that FERPA has its own timing element to it. It provides 45 days to comply with the request for records. This is contrasted with Missouri Sunshine Law, which, as I've said repeatedly, we have 3 days to respond to a request. So, the FERPA's 45 days really becomes a little bit meaningless when we have to comply with the 3-day Sunshine Law turnaround. It's just something to be aware of, that there is that separate timing element to it. So what do you do if you receive a parent request? So the first thing you should think through is, check is, does ODSM have the records or information that's being requested? If so, you should forward that information and the request to the Chief Counsel's office or your attorney's office. We'll take steps to verify the parent's identity and their entitlement to the information. And as part of that process, we'll contact the student's district to make sure it's aware of the request and can take any appropriate steps that are necessary. So let's do another pop quiz. We have a charter school that would like records for students that have left the charter school and enrolled in public schools in Missouri so that it can compare academic performance between those students who have stayed enrolled with the charter and those who didn't. Can the charter school have access to the requested education records? The answer is no. The school's not entitled to the information about those students because we think through, again, would the LEA or the charter school have been initially entitled to that information about those students? And no, because those students are no longer with the charter school. So let's talk about compliance with FERPA. And first we'll talk about how DESE state school employees can ensure compliance. And again, I hope the rest of you are still following along, even though this is more focused towards state school employees. The first is making sure that we send annual FERPA notices to parents that complies with FERPA requirements. One, we need to define directory information and how parents opt out. We've already kind of talked about that. We need to give instructions on how parents can inspect or amend educational records. We've already touched on that. We need to provide information on how parents can contact the U.S. Department of Education if they want to file complaints. And we need to give the criteria for how the state schools have designated school officials and what context a legitimate educational interest for the purpose of disclosures to school officials. And we've already talked about that as well. A second thing that's important is carefully reviewing agreements that require disclosure of educational records. So, cannot emphasize enough that third parties are bound by FERPA requirements to safeguard educational records. So anytime we're going to disclose records to third parties, we need to be mindful of how that disclosure will work and what that looks like. So make sure that we're looking at our third-party disclosures to providers like our therapists, our classroom applications or apps like Google Classroom, and I'm not singling out Google Classroom, but we're really looking at those provider agreements or vendor agreements and what those terms of service are. Our disclosures at the request of parents. And again, thinking back to what those requirements are for a disclosure to a parent at the parent's request or a disclosure to a third party at the parent's request. Doesn't meet all those requirements. And then we've talked about special steps that the state schools need to take, but let's talk about DESE employees next and the special steps that all of us need to take. And the first is so important, and it's kind of the heart of this presentation. We need to have focused awareness on the need to protect student PII. This information is entrusted to us. It's our legal responsibility, it's our ethical responsibility to safeguard it. We only release student data if there's parental consent or if the release meets a FERPA exception. And then, keeping in mind that if we're releasing student data because of we're entering into a studies or audit evaluation MOA, there is actually an MOA in place. It's a written MOA and it's been vetted by ODSM and legal. And I emphasize this one because in the past, I know there have been some data sharing agreements that have not necessarily been formalized. They haven't been vetted. And I know that that's, we're doing better on that, and I just want to make sure that we, keep that up and that we're really, very precise in our procedures for data sharing. And all of those go through the formal process through ODSM. So we never share educational records with PII outside of the state email system or Outlook without encrypting those messages. If you have questions on how to do that, please contact me. We always PDF documents that contain redactions or even changes to the documents. And by that I mean if you have a Word document and you've made changes to it, just remove the metadata. And if you have questions on how to do that, please contact me. Finally, we always use appropriate measures when we discuss and use PII. By that I mean, we are limiting our discussions about PII, especially educational PII, to those with legitimate educational interest, those who have a need to know, not just our friend or coworker down the hall. PII should never be left accessible or unattended in our offices, even at home. And then if there's a data breach, we report it to the data breach reporting website. And if you have any questions on how to handle a data breach, or if there is in fact a data breach, you need to look at the data breach procedure that's on the data governance section of the intranet. And then finally, some steps that we can take as an organization to ensure our data doesn't reveal PII. A couple of techniques we're going to talk about. And some of these you may be familiar with, some of them you may not. The first is redaction. And redaction is obscuring sensitive text from a document. And basically, it's blacking out text. And, you may be familiar from, work on sunshine law requests with redaction. We make sure that we're reading the document carefully so that PII is not also revealed through the context of any remaining text. And by that, I mean, let's say my name is what we're trying to, or my identity is what we're trying to redact and trying to conceal as PII. So the first example would be in this sentence, Sarah Madden works at DESE. Well, that would be very easy to redact, right? You just redact my name. So let's say the next sentence is, she is an attorney and has been there for almost 3 years. She drives a red Mini Cooper. So what would you consider PII in that sentence? What would need to be redacted? Well, we know, or you may know, there's more than one female attorney at DESE. So probably redacting, she's been there for more than 3 years, or more than 3 years would be what you'd redact in the first sentence. And then in the second sentence, a red Mini Cooper. She drives a red Mini Cooper. The red Mini Cooper singles me out as an attorney who is the one female attorney who drives a red Mini Cooper. I don't think there are any others at DESE. So you need to think about the context of the sentence and what other identifying information that we sort of talked about at the beginning of the presentation is also PII in what you're looking at. And along with redaction, we have suppression. And suppression is removing data in a cell or a row that prevents the identification of PII with groups of unique characteristics. And if you have questions about our protocols for suppression, you can find them on the intranet in the data governance policy on data privacy and suppression protocols. And this, so, just to explain how this works, this is when we're already de-identifying data by aggregating it. So groups of data are provided. So this would be, cells or rows of information that are then going to be suppressed or hidden because they reveal, or they could reveal, identifying information about students. So it could be by race, age, IEP, free or reduced lunch status, categories of information like that. That again, could be other identifying information about a student or students. So, I hate ending our presentation on this note, but it's at the end of the FERPA regulations, and this is where we will end too. What are the consequences of violating FERPA? So parties who believe that FERPA has been violated can contact the Student Privacy Policy Office, or SPPO, which is not an easy acronym, to investigate the complaint. The U.S. Department of Education is authorized to issue enforcement actions to education agencies or recipients of federal funding or third parties. And those enforcement actions can include withholding future payments, issuing cease and desist orders, or terminating eligibility to receive funding. So what could that look like? Well, let's say, for example, that DESE has a data sharing MOA or MOU with, we'll make up a school called Ozarkia State University. And the university works with a vendor to do a data study. And the vendor then publishes a study or the study results with identifying information, which that's going to be in violation of the MOA and FERPA. So what could the U.S. Department of Education do? The U.S. Department of Education could withhold payments against DESE. It could issue a cease and desist order against the vendor. It could terminate eligibility to receive federal funding against both DESE and Ozarkia. We obviously all of this we are doing our very best to avoid, and we rely on all of our employees for assistance in doing that. So final thoughts here. Always call with questions. We don't want to guess our way through FERPA. That's not safe, and it doesn't honor the trust that students and families have placed in us. If you have questions, always feel free to give me a call. I am happy to help. And then, the final caveat is when in doubt, don't give it out. Give it some thought. And that's where, the phone call comes in, and we can talk it through and see what is appropriate and what's allowable under FERPA. I have my contact information here. Please always give me a call or send me a message, and I am always happy to help. Thank you so much for your time and attention. I really appreciate it.